Good morning, good afternoon, and good evening to all of you out there, regardless of where you're joining us from tonight. My name is Toby Gross. I am the owner of a small firearms instruction business and security consultative service named Mining Ridge Armory. And if you've landed here on my channel, either live and watching with me here tonight, or if you're watching this in replay, first off, I thank you for being here and I thank you for sharing some of your time. On this channel, we try to bring you some valuable content with regards to firearms, training, legal, mindset, those kinds of things. And we don't just spend a lot of time doing YouTube theatrics, so to speak, or running around looking cool for the camera. We actually spend quite a bit of time talking about mindset and laws and going into some of the deeper topics with regards in the security realm, the physical security realm. Tonight, we wanted to touch on a topic that's a little vague, to be perfectly honest with you, but one that a lot of people have asked me questions about in when I'm teaching some of our concealed carry classes here in the great state of North Carolina. So, rules of engagement for tonight. Those of you who are out there watching live, I can see a count of how many people are out there, and I can see that you're out there, but I can't see who you are, or I can't interact with you or answer any of your questions if you don't, ping me or say something in the chat over to the side there. So shoot me a chat, or shoot me some words. Let me know you're out there. Just a couple little, just quick, hey, how are you? Good evening, that kind of thing. If you're watching this in replay, again, I appreciate you coming by or stopping by the channel and checking out our content. Hopefully, it'll bring some value to you and give you some information that you didn't have before you came here today. Make you just one step smarter and one step better when it comes to protecting yourself and protecting those under the mantle of your protection. If you're joining us on replay, leave a comment below, and I will try my best to get back to you in a timely fashion with an answer to your questions if I know the answers or if I can find those answers. If I can't, then I will direct you hopefully to someone who can. So again, comment over here or comment below, and I will be sure to get back to you as soon as possible. So tonight's topic we're wanting to talk about, as the title mentions, is Citizens Arrest 101, or the ability to make a citizen's arrest in the state of North Carolina, and what the laws are for you as a citizen versus a law enforcement, what the rules of engagement are, and what you're looking at legally. Now, what made me want to approach this topic is, among other things that I'm certified to instruct, I'm an NRA training counselor. I take a lot of advanced firearms classes. I'm a situational awareness for employees certified instructor, so on and so forth. Refuse to be a victim, et cetera, et cetera, et cetera. So I spend a great deal of time in training, and among them, I am also a North Carolina concealed carry firearms instructor or concealed carry handgun instructor. And so I teach a lot of classes and I get a lot of questions. And some of those questions are a little vague. And so I wanted to go over those topics tonight and see if we could clarify a couple of them. So I'm going to take a pause here real quick and say hey to a couple people. We got Georgia Trucker, GA Trucker 69. How you doing, sir? Thanks for joining us here tonight. We got Midnight out there. And Midnight says, great topic today, man. You're right. I'm hoping this is going to be an educational one. It's going to be a little deep, a little confusing. I'm going to kind of snake around and wind a little bit to get back to where we need to be. And so you just kind of, if you'll stay with me a little bit to the end, if we're going to start up on top of the mountain, we're going to work our way down through the woods and into the village. We're going to punch our way into somebody's house, and we're going to work our way up and see if they got any cookies in the cupboard. But if you'll follow me along my snaking journey, it'll all kind of make sense at the end, because unfortunately, when it comes to a lot of these laws, there is no straightforward, black and white, cut and dry, 1, 2, 3 answer. Like, oh, this is the answer. This is how you do it. Bing, bang, boom, done. North Carolina, it ain't gonna make that easy for you. Let's just be frank. So I'm going to kick it off by reading basically what the Concealed Carry Handgun Training Manual, the information that North Carolina Department of Justice provides to trainees in North Carolina. So North Carolina, in order to get your concealed carry permit, you have to take a roughly 8-hour course, 2 hours of which is legal, where you read through this book and you discuss the use of deadly force laws in North Carolina, as well as concealed carry, reciprocity, definitions, our versions of, or our stance on where and where you can't carry, castle doctrine, so to speak, whether we have that or not, those kinds of things. And in amongst those topics on page 12, it starts talking about reasons you cannot use deadly force. So by this point in the book, you've gone through why you can and some of the definitions of a perfect versus an imperfect defense. And now it's starting to flash around and give examples of reasons that you cannot use deadly force or excessive force in any way, shape, form, or fashion. So I'm going to start there, and I'm going to read what North Carolina says to their North Carolina concealed carry handgun trainees about the ability to arrest or detain. I got nothing. I got nothing. I will say that as we get to those topics, that's a rather interesting topic that we might could touch on midnight and maybe hit another week is disarming the suspect, or the alleged bad guy, disarming them and what you would do with that firearm. But I don't know that I would want to keep the evidence necessarily, but that's pretty funny. I appreciate that. All right, so on page 12 of the concealed carry handgun manual, under bullet point E for reasons you cannot use deadly force, cannot. And now, before I even start doing all this, I want to make something clear. I got to give the whole, I didn't sleep at Howard Johnson's last night's speech. I'm not a lawyer. I'm not an attorney. I'm not licensed in North Carolina to practice law, give advice on law, do anything with regards to the law, legals, legalities. You can't rely on the information I'm giving you in this video, full disclaimer, as evidence or evidentiary to say, oh, well, Toby told me so it's got to be law. All I am certified in North Carolina to do is teach the use of deadly force laws as outlined in the North Carolina Department of Justice Concealed Carry Handgun Training Manual. That is all that I am licensed to do. That said, um, I run into a lot of these things. Okay, so where the manual leaves off details, say on reciprocity, for example, I have to deal with it in the real world, and I have to deal with it and do some research and actually come up with some stuff. While I may not be a lawyer and that kind of thing, I have taken several mindset and legal training courses, including Masada Ayub Group's Mag 20, citizens use of deadly force. I'm a constant student of research and reading books, including Mass's books, quite a few of his publications, articles, and so on and so forth, and training materials. And then, of course, I study North Carolina law as often as I possibly can. So, in particular, what drives that is not just my students asking the questions and me wanting to be able to give legitimate and legally sound advice. So that they're protected, but also stupid things come up. I know that sounds weird, but like you'll see stupid things on Facebook, like, can you wear a face mask, and still legally concealed carry? You'll hear people talk about, can a felon actually open carry a black powder pistol? Can a felon actually own a black powder pistol for self-defense? You get all these weird deviations of questions that are based in reality, and I can't just, as an instructor and in good conscience, just say, well, sucks to be you, go figure it out yourself. So I spend a great deal of time researching a lot of this stuff and digging into it to get the best and most legally sound answer I possibly can. So again, not a lawyer. This isn't legally binding. I'm not an attorney. Didn't sleep with Howard Johnson last night. I ain't pretending to be. None of the above. But the information I'm going to share with you tonight is what I'm aware of as of 7:30 2020 at 7:08 p.m. at night. It is what my understanding of the law and what my understanding of the research and General Statutes 15A 404, 15A 405, and General Statute 74C-3 pertaining to the use of deadly force in relation to whether or not a citizen of North Carolina can make a citizen's arrest and or detain someone in the commission of a crime or after commission of a crime, during or after commission of a crime. So a lot of this information, while it's specific for North Carolina, is good and relevant information in other states. In other words, your laws are going to vary as to whether you can or cannot make a citizen's arrest, what the level of interaction with that citizen arrest and the Fourth Amendment is, and so on. So I encourage you to do your own research. But a lot of the information that I'm going to share tonight is going to be universal. So stick with me and kind of listen and follow along this crazy train that I'm going to go on. So all that said, talking in circles, I am going to read page 12, paragraph E. You cannot use deadly force. That's a prelude. Quote, to arrest a criminal or prevent a criminal's escape. North Carolina law does not give a citizen the right to make a citizen's arrest. Since the power to make a citizen's arrest does not exist, the right to use deadly force to effect an arrest or prevent an escape is not given to citizens. No matter how serious the crime. A citizen cannot shoot to stop a fleeing criminal. Then it vaguely says, one sentence, citizens have limited power to detain under North Carolina General Statute 15A 404, subsection C. End quote. So again, North Carolina does not give a citizen the right to make citizens arrest. Since the power to make citizens arrest does not exist, the right to use deadly force to effect an arrest or prevent escape is not given to citizens. No matter how serious the crime, a citizen cannot shoot to stop a fleeing criminal. Citizens have limited power to detain under North Carolina General Statutes 15A 404C. So we're going to read 404, we're going to read 405, we're going to read 74C, and we're going to talk through some real world scenarios, and we're going to talk through things. Now, first thing I want to bring out is, and we're going to circle back. So put pin in that whole, no matter how serious the crime, no matter how serious the crime, you cannot shoot someone to stop a fleeing criminal. So put a pin in that, because we're going to talk about, as we talk through tonight, we're going to talk about equal force versus necessary force. So in North Carolina, a citizen has only the right to equal and equivalent force as was dealt to him, or as was observed, or as was being perpetrated upon him. So in other words, if somebody's coming at you with a knife, you can use deadly force, even if it's a pistol. The tool is agnostic. It is the level of force that you have the equal right to do. A law enforcement officer has necessary force rights. So in other words, he can go by law one level up, and he can exude or exert whatever necessary force to stop that criminal act, or to stop the criminal from doing any further criminal acts, because there's the legal and moral obligation for a law enforcement officer that if they let him go, they could go and do something bad. So like if he just robbed a store and you let him go, he could go do bad things. A great example of that, unfortunately, or a horrible example of that, unfortunately, is the Florida school shooting, right? That where the law enforcement officer stayed outside. Okay, now, not judging him by any stretch of the imaginations. I don't know the guy. I don't know the situations. I would never say such a thing. But that's a good example of necessary force, where since it wasn't stopped, or since no effort was made with necessary force to stop that action, then it led to further negative actions. So a citizen does not have that right. All we have is equal rights in North Carolina, equal force rights. So we do not have necessary force rights, but a law enforcement officer does. In addition, and these are going to come into play as we talk through this. Now, bear in mind also, and we'll talk about Tennessee versus Garner, 1985. Okay, you may want to go ahead and jot that down right now, because we're not going to go real in depth into it. But Tennessee versus Garner, 1985, and you can find it at Wikipedia or findlaw.com, those kinds of things. That directly deals with the subject of shooting a fleeing suspect, regardless of whether you're law enforcement or whether you're a private citizen. Take a breath here and check and make sure we don't have anything going on crazy. Yeah, Midnight said that he'll go ahead and judge him. He should have went in. I can let you say that, but unfortunately, I can't say that. I can't say that on air, but I'll let you say that since you just did, and I just repeated you on air. So that's between you, him, and God, whatever. All right, so I encourage you to write down Tennessee versus Garner, and we'll touch on it, but I'm not going to go into depth on that one tonight. That may be a topic for another week. Now, another point, you've got necessary versus equal force in North Carolina. Citizen has to do equal force, can't do necessary. So that's going to play into whether you can arrest or detain. The next thing that you need to understand in North Carolina is that North Carolina is a vicarious liability state. What that means is, if I defend someone else, not myself, if I defend someone else, then I am vicariously liable as though I were that person, that entity. So let's say I walk, just to give you a real world example, or a semi-real world example. If I walked around a dark corner into an alleyway and I saw a woman being raped with a guy holding a knife to her throat, okay? If I then drew my firearm and shot the guy on top, because I perceived that there was a deadly force encounter going there, and that at that moment in time, that's what I felt like was happening, I am vicariously liable as though I am the woman who was on the ground. So in North Carolina, I'm that woman. Same thing if I'm protecting myself, I'm me, right? If I'm protecting my son, I'm my son. If I'm protecting my wife, I'm my wife. I'm vicariously liable as though I am that person. Okay, so this will come into play. Now, take that exact same scenario and let's turn it around a little bit. Well, what if that woman had actually just tried to knife the guy on top of her, and he had wrestled the knife away and threw her down and was now on top of her defending himself with a knife and wasn't necessarily planning on killing her? He was just trying. That's just where they were at that moment in time, from a Greco-Roman, wrestling match kind of situation. I just shot a man who she had started the fight with. So she was the aggressor. She was the bad guy. She was had attempted homicide or murder on that guy. And then I shot him. I finished it for her. So guess what I am? I'm the bad guy. I came around the corner, saw a situation, didn't assess it correctly, didn't do what I needed to do, whether it be citizens detainment, which is what we're going to talk through tonight and where this is relevant. Didn't do what I should have done. And instead I popped off some lead into a guy who didn't deserve it, and then I'm vicariously liable as I'm the bad guy who's on the ground. Let's not even take it that deep. Let's say they were just doing aggressive role playing. What if they get their kinks from doing odd sexual things in public or in restaurants while everybody's watching, Mile High Club, those kinds of things. And one of their kinks is, to step it up a game. Welcome. Thanks for joining us. You joined at a rather odd time where we're talking about the whole kink and and weird things. So apologize for that. I don't tend to be very tactful. I tend to be very realistic and very real in my training situations, because I want people to understand, that this is real and this stuff can really, really go crazy. So again, let's say that their kink was, and that they're trying to do aggressive role playing and kick it up a notch. And you walked around the corner. It was actually a husband and wife. You just capped her husband. You think that's going to go well? For you in court? Probably not. So again, stair stacking it. So we've got necessary versus equal force. We've got the fact that North Carolina is a vicarious liability state. Now, another element here that's going to play into the conversation tonight that you need to understand, and all this is going somewhere, is that North Carolina gives you the right to use deadly force to protect life of yourself or anyone under the mantle of your protection. Again, you've heard me say it time and time and time again, and you'll hear Massad Ayub say it. Immediate and otherwise unavoidable danger of death or grave bodily injury to the innocent. Right. So you've got the right to use deadly force to protect life, but not to protect property. Okay. So again, we're going to talk about some situations where, what if you came into a house and somebody was stealing your TV? Can you arrest them? Can you detain them in North Carolina? That kind of thing. And they're stealing your TV. I won't give away the answer, but you can probably guess where I'm going with some of this. Since you do not have the right to use deadly force in North Carolina to stop theft of property, and you do not have the right to arrest, but you do have limited rights to detain, you can probably see where I'm going to go with some of this conversation. All right. So let's talk about arrest versus detain real quick, and then we're going to jump into reading actual 404, 15A 404. So in North Carolina, arrest versus detain. So arrest is by definition, your Fourth Amendment. You cannot, you got to have probable cause. You have to have the ability and right and probable cause to be able to arrest or arrest someone and take away their freedom. Right, because that's what you're doing. You're arresting their freedom. You're taking away their freedom and locking them up in such a way that they cannot get away, that they are no longer of their own under their own power, under their own volition to be able to escape. That is what you are doing. Detain means that theoretically they could leave. Right. So if I'm just detaining you or stopping you, but I'm not arresting you, it's not, you still have the ability to leave or to maneuver, to get away, or to just walk away or what have you. So arrest versus detain is a thing in North Carolina, which leads us into where it mentions, again, I'll read that sentence real quick, that last part of the sentence from the Red Book. North Carolina citizens have a limited power to detain under North Carolina General Statute 15A 404C. So let's pull that up on screen real quick. I'm going to leave that up. And again, forgive me if you're commenting or anything like that. I'm trying to keep up and do all this all at the same time. It's a real chore. All right. So Tennessee versus Garner is the one I got pulled up there on the screen. That's just hint, hint, go check that out. Hint, hint, go check that out. Hint, hint, go check that out. That's a separate conversation for a separate day, but that's the whole where the law was debated and actually went to court for shooting a suspect while fleeing. All right, so North Carolina General Statute 15A 404, the rights that a citizen of North Carolina has for detention versus arrest. So definition of offenders by private persons. A, no arrest, period. Just flat out cannot. But detention is permitted. No private person may arrest another person except as provided by General Statute 15A 405, which we'll talk about here in just a minute. A private person may detain another person as provided in this section when detention is permitted. A private person may detain another person when he has probable cause. So again, we're back to that Fourth Amendment, right? That does come into play quite a bit when we're talking through North Carolina's rights for detention versus arrest. Has probable cause to believe that the person detained has committed in his presence. Again, remember we talked about walking around the corner and seeing the husband and wife there. In your presence, you witnessed a felony, a breach of the peace, which is pretty vague, a crime involving physical injury to another person that you witnessed, or a crime involving theft or destruction of property. Okay, not deadly force, but detain ability. Okay, so we'll get to that. So the manner of detention. The detention must be in a reasonable manner considering the offense involved and the circumstances of the detention. So again, citizen has to do equal force, not necessary force, equal force. The period of detention. The detention may be no longer than the time required for the earliest of the following. One, the detention that no offense has been committed, or the determination rather, that no offense has been committed. Turns out you were wrong. Got to let them go. Still better call the police, make a report, because then you're the bad guy. You detain someone and you could potentially be, civil sued, or something could come against you because you didn't report it. You look like the bad guy. Okay. Number two, the surrender of the person detained to a law enforcement officer as provided in subsection E. Surrender to officer. A private person who detains another must immediately notify a law enforcement officer and must, unless he releases the person earlier as required by subsection D, surrender the person detained to the law enforcement officer. All right. So that's a lot of legal mumbo jumbo, a lot of gray area and wiggle room in there. So now we're going to talk about 405. We're going to talk about 405. We're going to talk about a couple of very specific court cases, including the State versus Weaver and State versus Verkerk. Forgive me for slaughtering your name if you're out there listening to this Verkerk or watching it in replay. We're going to talk about those two and how they kind of polarized and gave an exact opposite view. We're going to talk that through, and we're going to talk about what that 405 is and the Fourth Amendment and how that relates. So let's jump over to 405 in a linear fashion. So you can't arrest, you can detain, as long as you saw it happen: a felony, a breach of peace, crime involving injured person, crime involving theft or destruction. You can't use anything but equal force, and you can only detain them as long as until you figure out they didn't do it, or until the police officers arrive and you can hand it to them. Now, you do have the right to arrest in one circumstance, and that is 15A 405. The assistance to law enforcement officers by private persons to effect arrest or prevent escape, benefits for private persons. Assistance upon request. Authority. Private persons may assist law enforcement officers in effecting arrests and preventing escapes from custody when requested to do so by the officer. When so requested, a private person has the same authority to effect an arrest or prevent escape from custody as the officer making the request. He does not incur civil or criminal liability for an invalid arrest unless he knows the arrest to be invalid. Nothing in this subsection constitutes justification for willful, malicious, or criminally negligent conduct by such persons, which injures or endangers any persons or property, nor shall it be construed to excuse or justify the use of unreasonable or excessive force. So all that's saying basically is, if a law enforcement officer, let's say he's alone and he's surrounded by a group of guys, he's trying to arrest somebody and he feels like he's getting overwhelmed or outnumbered and he feels like the odds are not in his favor and he asks you to help him, it's like the old, deputizing them in the old Westerns. Not obviously that's not what it really is, because this is modern times and, we don't want gun smoke around here, but it's like that. You are now a duly temporarily, ordained, so to speak, agent of that law enforcement officer at that time. And he has asked you to help him resist or to enact that arrest. Now, again, You've got to know that the person deserves to be arrested, or just be obeying, or can prove that at that moment in time, with the consideration of the totality of all the evidence and the current situation that you were in, that at that moment in time, your understanding of the situation in the law was that you didn't know for sure, but the law enforcement officer told you to help, so you did. Right. So you either got to know it happened, or you got to be able to prove and articulate to a jury of your peers that you were obeying the police officer and that you should have obeyed the police officer. During this arrest, even though you have been, temporarily deputized or whatever the case may be, you cannot use excessive force. Again, equal force. You can't be criminally negligent, malicious. You can't just be mean or kicking them, or grab the officer's billy club and be smacking him around while he's trying to put the handcuffs on. You can't be doing that kind of stuff. You can't be a jackbooted thug. Period. But more importantly, also, and this is a good point. So in North Carolina, if you have a perfect defense for use of deadly force, which is the 2 yeses and 2 nos, again, a topic for a different day. In North Carolina, you are immune from civil or criminal liability. You can't be sued by the family members. Well, it's the same for if a police officer asks you to help him make an arrest. You do not incur civil or criminal liabilities for an invalid arrest. So if it turns out he was wrong and he shouldn't have arrested the person to begin with, you can't be held reliable. He's going to get in trouble. He or she is going to have definitely, some splaining to do. Okay, but you're fine. All right. So another couple things real quick is these are just definitions of the terms and how it all applies. Some things that were repealed, but I do want to touch on this because it's going to make a little bit. It's going to make a little bit of a difference, right? So where's 74C3? Yeah. So and this is where it gets sticky and gray, and that's why I'm hesitating. I'm trying to think of how to best word this. Okay. To be treated as an employee or employer of the law enforcement officer within the meanings of General Statute 97-2 Workers' Compensation Act. Okay. So because of the need and the requirement of the Fourth Amendment to still exist, regardless of whether you're making a citizen's detainment or whether you're making, assisting a law enforcement officer who has asked you for an arrest, and because of the fact that any state-sponsored employee, whether it be law enforcement or some other agencies that are employed directly by the North Carolina government, have the legal responsibility to fulfill the rights of the Fourth Amendment so that they are not breaching your rights as a citizen of the United States. There gets to be some sticky areas, like, for example, if you're a fireman, or if you're a game warden, or if you're those kinds of things. Okay, there gets to be some really gray and sticky areas, and we're going to talk through a couple of cases that specifically dealt with 2 of those situations. But before we do that, real quick, I want to touch on private protective services. Okay, so in the case of not Weaver, not Verkirk, can't remember the case, and I don't have it jotted down here, so shame on me. I don't have it jotted down in my notes. Anyways, there was a yeah, that's it. So Parker versus Hyatt. Okay, so in the case of Parker versus Hyatt in North Carolina, there was a security guard at the UNC Wilmington who was a security guard. He was a security profession. Okay, he was a private protective service and was considered so. He was not considered a state agent, state actor, or so on. He witnessed a DUI that was occurring on campus or in the vicinity of the campus. Called local law enforcement. Local law enforcement showed up. They tried to get the evidence kicked out because he was not law enforcement and he did not have the necessary probable cause and so on and so forth. And yet they kept the evidence because they were saying he was not a state employed actor. He was a personal private protective service employee. And that's what 74C3 defines, is what the definition of that is. And I'm not going to read through this. I encourage you, though, I can click down through it and you can pause the screen and read it as I click down through it one page at a time, or you can look it up on your own. That is North Carolina General Statute 74C Section 3. But short version of all that is that that private security personnel was not a law enforcement officer, so he didn't necessarily have the depth to show the Fourth Amendment or probable cause to the depth that a law enforcement officer would. And so they did allow it was admissible in court. They did allow the DUI to go through and to work through. However, as we talked through Weaver, or I'm sorry, that was a State versus Weaver. No, I'm sorry. As we talk through the State versus Weaver and the State versus Kirk, it's going to be a little bit different. So forgive me for slaughtering these names, by the way. But the Fourth Amendment, and the reason I'm harping this and I'm showing this slowly but surely for you to be able to pause and read if you choose to do so, is the Fourth Amendment comes into play and makes it a gray area, regardless of whether you're a citizen or whether you're a law enforcement. And it gives gray areas because of what the definition of, what is your rights as a citizen, what is your expectations with other citizens, and what is your expectations of state-sponsored actors who are arresting or detaining your escape, or detaining you from leaving, or arresting you and stopping your freedoms. So let's punch through this real quick. Then we will jump over to State versus Weaver. Okay. And I'll throw links to all these out here in just a minute in the chat. If y'all remind me, don't want to forget. All right. So State versus Weaver. So State versus Weaver 772 SE 2D 240 in 2013. So basically, a guy was stopped by a security guard for a town home community who thought the defendant was speeding. The security guard approached the defendant's car. I'm going to read this whole one, and then the State versus Verkirk, I won't read all the way. The security guard approached the defendant's car and identified himself as Officer Hunter from the Metro's Public Safety. Okay, Officer Hunter from Metro Public Safety. The guard smelled alcohol on the defendant and noticed that the defendant's eyes were bloodshot. The guard asked the defendant whether he had been drinking, and the defendant said that he had not, or that he had, rather. The guard asked the defendant to get out of the car and to sit on the sidewalk. He didn't point a gun at him. He didn't put handcuffs on him. He didn't use any kind of force. He just asked him to get out of the car and sit on the sidewalk. He called dispatch and asked the city police to send an officer for possible DUI. Defendant, who subsequently was charged by DUI by a Wilmington police officer, so I am crossing up my story, sorry about that, moved to suppress the evidence gathered as a result of the stop. Trial court granted the motion, but the Court of Appeals reversed it, holding that security guard was not a state actor, and thus the Fourth Amendment did not apply. Now, we already touched on the fact that as a citizen, that Fourth Amendment is going to come into play sometimes, and sometimes it's not. We've touched on the fact that by definition, what a security professional is defined at, or a private protective, protective services is defined as. So this guy was a full-blown security officer, right? He wasn't just you or I, who's an average citizen who's having to deal with these nuances. But again, bear in mind, he was respectful. He didn't touch the guy. He didn't use a firearm. He didn't use anything. He just asked him. He detained him. The guy could have got up and left. Guy could have told him no. Guy could have got back his car and drove off. At that point in time, the only thing that security guard would have had the legal right to do is he could have tried to follow him according to what their SOP is for that particular security detail. But legally, the only recourse he had was to call the cops, give him his tag number, a description of the car, tell him what direction he had last seen him heading. And that's it. There is no equal force that he could have used, and no justification for equal level of force to detain or stop that individual from leaving for any reason, even though it is arguable that with him being drunk and bloodshot eyes, theoretically, he could have went out and had a car accident and took the life of another individual, thus taking away the life and liberty of another citizen of the United States of America and of North Carolina. So there's some real weird gray areas in there. So legally, he couldn't physically use force to detain the guy. He couldn't arrest him. But it is arguable in a court of law that based on the evidence that was available to him at that time and the totality of the consideration of the circumstances at that time, that it was entirely possible that that he could have left and caused physical harm to someone else. So then you have a situation where you're talking about the doctrine of competing harms. Okay, so the doctrine of competing harms is the concept of, we'll just use driving as an example. So I'm driving down the road, 2-lane highway, double yellow line. I know by North Carolina and federal law, I cannot pass into the oncoming traffic or the opposing lane over the double yellow line. Obviously, got my wife and my kids with me in the car and my little dog. Up ahead, I see an erratic driver weaving, and he's bobbing and weaving over the lines. My gut's telling me he's a drunk driver or an erratic driver, or something's going on inside that car that could potentially cause harm to other people. I see him drifting into my lane. I know that in fact I'm not going to have time if I continue to follow the law. I'm going to potentially have physical bodily harm, or those in the mantle of my protection could also have physical body harm. So I'm going to break the law because of the doctrine of competing harms. If I stayed in the lane that I was in and continued to follow the law, then I'm going to be under more harm than I would if I broke the law and got in trouble and got a violation or ticket for breaking that law. So you're under the doctrine of competing harms. So that didn't come up in this case. They did end up holding it back, but that could have been one of the elements that came into play, was the doctrine of competing harms. Had he have let this guy go because he knew he couldn't arrest him and he only had limited powers to detain, he could have argued, he could have potentially with a good lawyer and a good backing and a crazy amount of time and a crazy amount of money, unfortunately, could have argued the doctrine of competing harms, that he was, he feared that others in the public safety of the public realm could have been harmed by this guy continuing to drive. Now, in that case, I don't have an answer for you as to what he could have done. I don't know what the equal. I don't know. He definitely couldn't use deadly force. I can guarantee you that. In North Carolina, that would not have been allowed, and it would not fall under the definitions of Tennessee versus Garner for the reasons that you can shoot a fleeing suspect. It wouldn't fall under those auspices either, which is federal law. I don't know what the answer is. That's one of those gray areas, and I wish I had you a black and white answer for it, but I don't. I can tell you that I personally, I don't know what I would do, but I would like to think in that situation I would do something, whether it's, try to snag the guy's keys away from him, whether it's to walk over and poke a hole in his tire with my pocket knife, and then be willing to buy the guy a new tire. I don't know. I don't know. But I know that weird gray area with necessary force versus, equal force versus necessary force, arrest versus detain, and that Fourth Amendment thing in North Carolina makes it a very sticky situation. Which leads us to the state versus Verkirk. So in the state versus Verkirk, similar. So firefighter in Chapel Hill Fire Department saw a car being driven in heavy rain. Windows down, headlights were illuminated. Vehicle was traveling about 15 miles below the speed limit and was repeatedly just drifting and crossing the center line. Okay. Basically, firefighter rolled or called it in, had the police on the way, pulled up beside the guy, turned on the fire truck lights. Okay, he was in his fire truck. He wasn't in his personal vehicle. Threw on the fire truck lights. Car pulled over to the right, hit the curb, came to a stop. Firefighter called a third time, got out of his truck to speak to the driver. Okay, so basically the driver saw the lights, for whatever reason, assumed it was an actor or an official of the state, so to speak, that he would comply with. Pulled over to the side. Guy didn't make an arrest, right? So, well, let me rephrase that. He didn't arrest the guy. He just walked over to talk to him. Okay. The gentleman's lawyer in court tried to say that there was no determination or probable cause of Fourth Amendment, because all he could have known was, for probable cause, he could have been just texting or trying to grab something in the floorboard, or could have been struggling with his seatbelt, or could have been doing this, or could have been doing that. There could have been any number of other reasons besides physical impairment or DUI that caused him to be bobbing and weaving and driving erratically. And so that fire department officer did not have the right to arrest him or detain him, either one. And that since he was a firefighter, it constituted an arrest as opposed to a detainment and a violation of his Fourth Amendment rights. Now, the Court of Appeals over dissent reversed the trial and remanded for additional findings regarding whether the firefighter was acting as a private citizen or a government agent. And therein lies the key, right? So the fact that he was operating a governmental vehicle under governmental umbrella of firefighter and so on and so forth, gave it that sticky, weird gray area. Okay. They held that the trial court erred in determining that the firefighter's actions were lawful under the General Statute 404, explaining that a citizen, again, remember we said they don't have to have probable cause. Now this court's finding is saying that they do. A citizen must have probable cause to detain another, and that nothing in General Statute 15A404 authorizes private citizens to conduct investigatory stops based on reasonable, articulable suspicion for the purpose of ascertaining whether a criminal offense has been committed. So again, it's that whole "did you see it happen" versus "well, I think it happened." Okay. So the appellate court opined that at the time the firefighter stopped the vehicle, he was conducting at most an investigative stop, as he did not know whether she was impaired driver or whether her erratic driving stemmed from an entirely different cause, such as illness or mechanical difficulties, like I'd said. All right, so bottom line is that one got sticky and got overturned and it got weird. And you're seeing how through these laws, you're seeing do need probable cause, don't need probable cause, can be a citizen, but if a law enforcement officer tells you to help, then you can make an arrest. You can't do anything but detain, but arrest. So unfortunately, this gets into the whole part where I was saying that it's gray and that I can give you my best advice that I can possibly give you. First piece of advice, and we'll start bringing this home. The first piece of advice is find a really good local lawyer, consult them, have them on retainer, keep them on your speed dial, those kinds of things. Okay. Uh, Carry a good concealed carry insurance like USCCA or the one that Mossad Ayub, which is a Citizens Defense Group, I think, a really good and reputable concealed carry insurance agency to help with the legal battle that's going to potentially ensue. Make sure that you do not arrest an individual regardless of what they have done, arrest their escape, that you are only detaining, and we will talk about that here in just a minute. Assure that you only have equal force that you're using in any given situation, regardless of what tool you're using, whether it be your words, whether it be physical hands and restraints, whatever the case may be. Make sure that you saw it happen, and we're going to pop back to 404 here real quick. Make sure that it was a felony, breach of peace, physical injury to another person, crime involving theft or destruction of property, and that you saw it happen. Okay, that you're absolutely 100% able to articulate that you saw that happen. Okay, now the probable cause thing is then kind of knocked out of the window. If you saw it happen, that gives you probable cause. So the Fourth Amendment then isn't so much of a sticking, except for the arrest versus detain. It's not a sticking point except for the arrest versus detain. So now let's talk about how to detain. Let's take that scenario that I gave earlier, and that I rounded the corner and there was a man on top of the woman with a knife to her throat behind the dumpster. In good conscience, by law, I can walk away. North Carolina does not have a Good Samaritan's law where you are required to do anything for the armed citizens. You can literally just go, not my problem. Sucks to be you. One less breeder for the gene pool. You're a horrible human being. You have to look yourself in the face every day thereafter. You will have to sleep with that. You will have to know that, and you will have to live with that. And you are disgusting as a human being. That's purely my opinion. That's not the law. And I would hope that you would not do that. So then what do you do? Well, at that moment in time, you do not know what's going on. So I'm going to talk to you about detaining without necessarily detaining without brandishing the firearm. We're going to talk about that next. But as I lead into this and as I get onto the topic, I want to make abundantly clear that these are the type of physical tactics and techniques that are more advanced tactics and techniques than just your average. My Uncle Joe showed me how to shoot out by the pond, and I've taken a concealed carry class in my state, so I'm good to go. I very, 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 very strongly encourage you to take official formalized training for anything we're going to talk about from here forward. I also, as I encouraged you at the beginning of this, encourage you to take legal and mindset training for anything that we've talked about up to now. And I also encourage you very strongly to research your state's laws and to talk to seek legal advice from a local attorney in your area on the topics that we have covered now and as relates to your state and in North Carolina. But now I want to talk about some tactics and techniques to use in detainment of a situation, containment and detainment of an individual. Containment of a situation, detainment of an individual. Now, again, bear in mind as I'm telling you all of this, you can't arrest someone and you can't actually stop them from leaving. That said, they may not know that. Okay. They may not know what the law is, and they may not know that you can't do a citizen's arrest. They may not know that they can get up and just walk off. Okay. So there are ways such as, that you would learn, say, through mental mindset training and tactics and techniques training, through some of your more advanced CQB classes, some of your more advanced NRA classes like personal protection inside the home, personal protection outside the home, those kinds of classes and courses of fire. You learn some techniques and tactics on how to detain individuals without brandishing, for one, brandishing. Hey, Nighthawk Medic, welcome. Thank you for showing up. Appreciate you stopping in. I can find my little clicker here. What's up, buddy? Appreciate you being here. There are ways to do it without necessarily brandishing. Brandishing would be, so if I pull out and I go low ready, so if I walked around the corner, saw the guy, knife on the woman's throat, I pull out and I go to the low ready, and I start yelling and asking questions. I start yelling, ask the lady if she's okay, what's going on, do you need some help, what's going on, hey, stop that, step away from her. But I'm not brandishing it by pointing it at that individual. And again, there are armed to the terror public laws in North Carolina, separate conversation for a separate day, and how this plays in. At my earliest convenience, obviously, mental mindset, I'm also going to be calling law enforcement because I just pulled out my firearm. They could go around the corner and be like, I was just minding my own business. I was hitting up this girl, and we were hitting it off really well, and she was telling me we were going to meet at the club later tonight. Next thing I know, this crazy guy walked around the corner and pulled a gun on me. Okay. So obviously you're going to engage law enforcement at your earliest possible convenience, not that moment in time, because you're trying to control the situation with a firearm, right? But you don't point it at the individual. Therefore, it is not brandishing. It is merely you pulling out a firearm and holding it and asking a lot of loud questions. Okay. Now, based on the actions of that individual, again, where we talked about, he may not know that he can or cannot leave the situation from a detainment perspective, right? So remember the security guard we talked about. He just asked the guy to sit down. Hey man, can you sit down over here on the sidewalk? Guy did it. Guy complied. He didn't know he didn't have to. He didn't know that it wasn't, there was an option to where he could just say, screw you, man, I'm out of here, So if I pulled out my firearm and I started yelling questions, say, hey man, I need you to step over there to the wall. I need you to step over the wall, or even I need you to get face down. Don't talk. I don't want to hear your mouth. Don't speak. I need you face down. I need you faced away from me. Spread your legs. Point your toes out. Opposite. I want you to put your arms out. To the 90-degree angles from your body. Spread your fingers wide open. Stick them way up above your head. Face down. Turn your face away from me. Do not look at me. Do not look at me. At no point in time pointing the firearm at the individual. Therefore, you're not brandishing, right? You're just yelling a bunch of commands, and he's complying. Now, is there an arm to the terror of the public element there? Is there the ability that he may be able to come up with a legal defense, against you to say that you were intimidating him or threatening him through use of potential deadly force? Absolutely. Freaking-lutely. Are you probably going to get sued in civil court, civil liability? Sorry, but yeah. In the world we live in today, probably. You know how this goes. You've seen it on the news media too many times. Hey, he was a fine, outstanding citizen. He was getting his life together. Look at these cool pictures of him when he was in high school. Cool story, bro. Cool story, bro. And he was just hitting that girl up. He was trying to ask her out. Never is anything mentioned about the knife. And all of a sudden the knife magically disappeared because he chunked it up under, he chunked it up and one of his buddies come around the corner and grabbed it and it disappeared, right? Those kinds of things. Okay. So are you going to get in legal trouble? Probably, which is why you need to call the law enforcement as quickly as possible. But can you just walk away from the situation and let it happen, knowing that woman was probably getting ready to get shanked? These are decisions you've got to understand the nuances of and make for yourself. And in that time, amen. Get away. Well, I wouldn't get away. I would actually stick around and answer questions for the law enforcement officer, but definitely hand them off as quickly as possible. Okay, so back to the scenario, right? So I've come around the corner, pulled it out, not brandishing, not pointing it at the individual, pointing it down the ground, yelling and asking the lady questions, giving the guy commands, get away, step away from her, shut up, don't speak, look away from me, keep your hands where I can see them, point your feet down, et cetera, et cetera, et cetera. Okay. He can get up and walk away, right? But if he doesn't know that he can get up and walk away, then you're only detaining him. You are not arresting him. You haven't physically touched him. You haven't shot at him. You haven't pointed your firearm at him. You haven't brandished. You haven't done anything. You are merely posturing in such a way as to protect yourself and to protect those under the mantle of your protection, which at that moment in time is that lady laying there who you are already a vicarious liability actor as though you are her, right? And you're trying to ascertain what's going on in the situation. At your earliest possible convenience, you yell and tell her to call the police, or you can try to get the police while holding the firearm, that kind of thing. Okay, so that's a detainment situation in a very aggressive and high-level situation. Let's take it down a notch. Let's say I walked into my house and I saw a guy who's stealing my living room TV. Okay. Now in North Carolina, I can't use deadly force to protect property. We talked about that at the very beginning of the show. But what I can do is do an escalation of force. Okay. So I can't arrest him. I can't use deadly force on him to stop him from to steal my property. Now, if he's stealing my TV and he pulls a gun on me, different conversation. I'm using deadly force to protect life. I'm not using deadly force to protect the property. But if he's just trying to walk out the door with the TV, I can't shoot him and I can't arrest him. But I can use either escalation of force. Page 18, section 3 says escalation of force. Escalation of force is merely the increase in the level of force based on that force which is being used against you. Force must be proportionate to the level of force used against you. For instance, if you are verbally assaulted, you cannot use deadly force to settle the argument. If we were to look at the various levels of force, the escalation would be something like this. Physical presence. Verbal, you ask them to leave. Soft hands, which are gently guiding them to leave. Hard hands, forced to leave with fists. Chemical, mace, OC spray. Impact weapons, such as a stick or club. And then, of course, deadly force is the last option, and that's used only to protect your life, not to protect property. Okay. Now, North Carolina law does give you the right to use relatively reasonable yet equal force to save your property. So in other words, when I walk in, guy's pulling the TV down off the wall, he's not threatening me, he's got the TV, he's trying to leave. I can't arrest him, but I can go lay hands on him and get my TV back because it's my TV, and I have the right to defend myself in my home, and I have the right to defend my property, not by use of deadly force or by use of necessary force, only by use of equal force, right? So whatever he's doing, if he's not armed, I can use gentle hands or what have you and take it away from him, or closed hands, those kinds of things to get my stuff back and get him out the door. Now, let's flip that to say that you just walked into the door, you see the guy stealing your TV, you think you hear noises in another room, so you don't know if you're outnumbered, you don't know what situation is going on. Run like hell. Hit the door, get out. Okay, don't stay, don't be a hero, don't try to use these laws to defend yourself. That said, though, let's say that you're going to Roadhouse. And you're right, not Hawk Medic. In smaller towns, your local magistrate might end up being the person of ordinary firmness you have to deal with. Okay, so back to the situation though. Let's say, and you don't know if your son or daughter's still there. You heard that noise in the back. You don't know if it's your son or daughter. You don't know if it's your wife. You don't know if somebody else is there. So suddenly it changes the dynamic of the situation to where the consideration of the totality of the circumstances, you're not just defending that TV. You got a separate situation you've got to attend to and you got to look at, right? So is that a time when you may have to detain them or attempt to detain for different reasons and different causes so that you can ascertain what else is going on in the house, make sure that everybody else is safe, get yourself together and get yourself out of there, make sure there's not other, nefarious actors in play, that kind of thing? Absolutely. So again, we walk back to the situation of if it would be necessary to detain them, and you've ruled out the option that you couldn't just physically go get your stuff from them. And to be frank, you've got to live with yourself and you've got to live with the legal ramifications of this. Is a $600, $700, $800 TV really worth even just, what, bro, just take it and leave? Is it worth fighting past all that to even have to deal with all these laws? So again, it's only in the scenarios in my mind where you don't know if a family member's still there, or you may have to get a little further into the house to check and see what's going. In those situations, again, the same detain without brandishing would apply, right? So you would hold low, ready, or Sul. You're yelling orders. You're telling them get down, get down, get down. Put the TV down. Whatever. Please don't break my TV or drop the TV. Whatever. Actually, you should drop the TV, even though it's going to shatter it. You should drop because you want their hands controlled and visible at all times and as quickly as possible, because the hands are the weapons of the body. The mind thinks it out, then the hands enact it. So again, not pointing at them, not brandishing, so on and so forth, pointing down, just like we talked about with the lady in the alleyway, and you're giving them orders. If they're complying with the orders, that's not arresting, that's detention. Okay, and you have the right to detain North Carolina. Now, again, is there going to be that elements of firearms that you may have to deal with where they take charges against you for threat or assault with a deadly weapon? Probably. You know, are they going to get away with it? Probably not. You know, they're probably going to lose because they were the bad guy. They broke into your house. You can prove it, so on and so forth. You got the broken TV to prove it. You heard the sound in the background. You can articulate to a person of ordinary firmness and a jury of your peers the totality of the circumstances that made you make the decision to attempt to detain the individual. You contacted law enforcement at the earliest possible opportunity, et cetera, and so on and so forth. But is that any consolation when you had to spend, you know, $8,000-9,000 worth of legal fees, and then you had to miss, you know, weeks and weeks worth of work and end up losing your job? You were ostracized by people in your community. You lost, you know, again, had to go and find, you know, gainful employment. Your kids are getting shamed and made fun of at school because daddy's a thug and he pulled a gun on the guy and all that kind of stuff. Is it worth all that just for a TV? You know, you need to consider these things when you're thinking about detain versus, you know, detainment in the state of North Carolina, and the legal grayness and the legal just jelly that surrounds our unfortunate ability to detain in North Carolina versus arrest. Okay, so I think I've harped on a bunch of those subjects quite a bit. I do want to talk about Tennessee versus Garner just real quick and touch on it. So before I move on to that, what's up, Shooting Gallery Northeast? Thanks for joining us. You're joining right at the end. I appreciate you showing up. So please go back and watch this one. Hopefully it's got some good information with regards to citizens arrest and detainment in the state of North Carolina, as well as some of the legal nuances that are going to apply regardless of what state you're in. You know, most of the legal nuances I've talked about your life getting ruined, having to pay a lawyer, so on and so forth. It's going to apply no matter where you're at. You know, it's going to hit you. So Tennessee versus Garner, real quick, 1985. Look at finelaw.com. Okay. Now, you do not have a duty to stop a crime because you're a citizen. But if you'll look up Tracy Thurman versus the city of Torrington, Tracy Thurman versus the city of Torrington, circa 1970. I don't know when it was. Okay. If you'll look that law up, you will find that you don't have a duty to stop anybody, and you don't have the right to use necessary force, only equal force. But you do have the right to attempt to stop a crime that is in commission. And then under the auspices of Tennessee versus Garner, and again, we got that on screen now. Under the auspices of Tennessee versus Garner, there are 6 very distinct reasons that you can, 6 very, very, very strict criteria that have to be met in order to shoot a fleeing suspect who is in commission of a crime or whatever the case may be. I'm not going to go into that. I'm going to tell you that if that's something that interests you on understanding the concepts of duty to stop and what requirements need to be met, the 6 requirements that need to be met in order to shoot a fleeing suspect, I encourage you to again, consult your local attorney and to look up these laws and do your research and do your homework. There are 6 very, very, very strict criterion, though. You've got to meet all of them to the letter of the law and to the T in order to keep yourself legally above board. Now, that said, just a real quick generic kind of thing. Not Hawk Medic brought out that it's those for Tennessee. Thank you, sir. I haven't researched those, so I can't speak to the validity of it. But if he's right, that's good information. I appreciate you looking that up for me. Midnight just gave, and I'll give that a second more on the screen there, so you can pause it and write that down if you want to. He just said the thing of things that I've been hinting at all night long. You're better off. Wouldn't it be better just to observe it and be a good witness for the police? Now, again, there's going to be those scenarios like when you rounded the corner and you saw someone, you know, getting potentially raped and that kind of thing. Midnight just clarified that that's on the amount of force. The Tennessee laws that he just mentioned there are on the amount of force that can be used in Tennessee, not necessarily necessary versus necessary versus equal, and citizen arrest and all that kind of stuff. Still good information. Thank you, sir. All right, so real quick, Tennessee versus Garner. So I'm going to drop these links out there in the chat. See if I can get this stuff to paste for you. All right, that one is North Carolina 15A 404. This one is 15A 405. This one is the definition in North Carolina of a private protective service protective services profession defined. This is a good article on criminallaw.sog at unc.edu. Really good article about what we talked about tonight. That gelatinous grayness of the law in North Carolina with regards to detainment versus arrest, and with regards to the nuances of the Fourth Amendment and some of the stuff that's going to kind of get you potentially jacked up. And then we went through again all those bullet points, and so now I'm going to sweep the floors and bring it home. The last one I just gave you was Tennessee versus Garner, for the 6 reasons, or the 6 very strict criteria that need to be met in order to exercise your right to detain or to use deadly force on a suspect in commission of a crime if it meets the 6 criteria. It's just generic use case that we've all seen on the movies. The token 24 scenario. If you saw a guy with a IED strapped to his chest, and he was heading into an elementary school, right? And his back was turned to you, and you were 5,000% sure that he had an IED, and that when you took him down, it was going to stop the IED, and it wasn't going to get in there to the kids and stuff. You damn well better try to take the shot, okay? Period. And try to talk to a lawyer and work with the courts and jury of your peers. You need to be doing that instead of letting that guy get in there with a IED into an elementary school. Okay, but that's just generic high level of what you're going to read with Tennessee versus Garner. It's the token movie scenario for the most part. So anyways, so bringing all this home, remember, North Carolina is a vicarious liability state. You are acting as though you are the person you are defending. You cannot use deadly force in North Carolina to protect property, only to protect life. A citizen does not have the right to make a citizen's arrest or arrest anyone, regardless of the status of the Fourth Amendment or probable cause that has been determined. But you do have limited rights to detain. With one exception, you can arrest if under 15A 405, a duly enforced law enforcement officer or duly ordained law enforcement officer gives you the right or requests your assistance, is the only time that you can arrest. Remember that there's a sticky element as to whether you're considered a state actor versus a private individual. Say, for example, if you're a fireman inside of a fire truck, an ambulance driver inside of an ambulance, a security guard operating for a township or local security. There are some sticky areas where the defendant, the person who the criminal, can actually get a good lawyer and try to jack you up and get that thrown out in court, because there's some weird nuances there for when and when you do not have to have probable cause. Otherwise, it's a violation of the Fourth Amendment. Remember, we talked about that, and go back and watch that. Remember that in North Carolina, you as a citizen are only allowed to use equal force, not necessary force. Equal only. You are only allowed to use equal force, period. Okay. And then finally, we discussed through two good legal examples with the State versus Weaver and State versus Verkirk, where it literally went both ways. One of one way and one of the other, of how that can come back and get you kind of twisted up. Remember that the Fourth Amendment is always out there for everyone, even for the bad guys. And you need to be respectful of that and know your Fourth Amendment up one side, down the other. And then remember that we talked through training scenarios for detainment, right? So you're not arresting an individual. If you're just detaining them, they still have the ability and the right to get up and leave, regardless of whether it's in commission of a crime, theft of property, or that. And you can't just shoot them, right? You can't shoot a fleeing suspect unless it meets the criterion of Tennessee versus Garner out of in 1985. But that doesn't mean that you can't be issuing orders while still trying to be the good guy yourself in such a way that can be articulated to a court of law, again, with the totality of the circumstances of what was going on at the time, in such a way that they just comply when they don't have to comply. So they can get up and leave, but if you're just telling them, shut up, get on the ground, those kinds of things like we talked about, and you're not brandishing or you're not threatening their life or you're not doing anything inappropriate, then that's just detainment. Okay, plain and simple. Just like the scenario we get, the first scenario for the State versus Weaver, security guard just asked him to sit down on the sidewalk, right? They sat down the sidewalk. It wasn't that they were pointing a gun at them or forcing them to stay there. They just complied. They could have gotten up and left at any time. And now we did touch on the doctrine of conflicting harms with regards to that subject. And again, I also encourage you to research that one very heavily to make sure that you understand all the nuances. So that brings us kind of to the end of into tonight's very confusing, very spaghetti-like webinar. And I do sincerely apologize for the fact that we had to bob and weave quite a bit, and that we would state something with certainty and then circle back on it and say that we are not certain on it. And the unfortunate reason for that is in North Carolina, the laws, as we've been mentioning all through, are very gray and are definitely open to our interpretation. They are common law. They are not statutory law. So they do bob and weave according to the circumstance, the situation, the DA, the current political environment, the actors involved. Was it a senator's grandson, who's got a lot of money and he was out drunk driving, and you detained him without the use of a firearm. You detained him, and then he's got more money than you. He just gets his way out of it. I mean, the sad reality of it is this: the world you live in today. But I wanted to do this video, even though it does meander backwards and forwards through it, because of the fact that North Carolina only gives you one paragraph to go off of whenever they're going through that topic in the book. And I often don't have the opportunity to go an hour into describing it for my classes because I'm only allowed 8 hours of time with them. So I did my reciprocity video last week. So if you're interested in that, check out the comments or check out the links below, subscribe, ring the bell, go back and look at my Reciprocity 101 video, something similar, where North Carolina only has, one sentence and one paragraph, and I spend 10 minutes, right, talking about it, if that, where I got to do a long form, 1 hour long discussion on my webinar last week, and I've got to do a 1 hour long webinar discussion about detainment versus arrest and how North Carolina does not allow for citizens arrest tonight. So I appreciate all of you taking this walk with me and listening to it, listening to my insanity. Those of you who stuck with me, again, I very much appreciate you being here tonight. Those of you who are watching a replay, thank you for your time. Please like and subscribe. If you found anything I said tonight offensive, or if you found anything I said tonight wrong, prove me wrong. Please, for the love of God, correct me in the comments below. Please correct me. Let me know I am way off base and there's such and such law and that you're telling people wrong. Please correct me. And remember, I'm not a lawyer. I'm not an attorney, right? And help keep us all honest. I will answer you as quickly as I possibly can if you do. Thank you very much, Nighthawk. I thought so too. There's a lot of things getting worse and worse, like you're just saying right here. A lot of things are getting worse and worse, and you're right. There is the possibility that eventually we may be faced with a situation exactly like this, where you're faced with a guy breaking the window on a store. Do you have the legal right to pull out a gun on him? No, not really, right? Do you have the legal right to tell him to sit down and shut up? Yeah. If he complies, he complies, right? It doesn't matter what state you're in. And ultimately speaking, like Midnight said, Roadhouse, Roadhouse. No, kidding. Don't do that. Don't lay hands on unless there's a reason to lay hands on. In North Carolina, I gave you the escalation of force if you'll scroll backwards in the video. But sweeping the floors, closing the doors. Thank you all very much for showing up tonight and participating in the chat. Those of you who are over here in the chat. Those of you who are watching this replay, check out the chat. There's some really good information and conversations going on over there. Again, if you have a question for me, leave it below. Like, thumbs up, do something organic, help me get some people over here to my channel. Hopefully my content's of value to somebody. And naturally, like I said, if you heard something wrong or feel like I'm telling people wrong, correct me and tell me, show me. I welcome, I beg for the feedback and beg for the correction. I beg for anybody who's got more knowledge than me to help me to always be ever growing and ever the student. So finally, thank you all for being here. Got a few more comments here. We'll check this out before we go. Big issue is when you step in and they don't comply. How and what do you do? Exactly. It's exactly right. You got to let them leave, right? Unless it meets the criterion of Tennessee versus Garner, 1985 at findlaw.com. which I encourage you to research, unless it meets those six criterion, those very six strict criterion, you can't stop them. You just be a really good witness for the police. Take notes, write down, physical appearance, what they were wearing, the direction they headed, any distinguishing characteristics such as limp or gait or noticeable tattoos or unusual shoes that you may have noticed that are not normal for the area or normal for the environment that you're in. Particularly tattoos, that's always a big one. Iconography is always a big one when it comes to heuristics and displays of territorial affiliations. Gang colors, potential gang colors, such as black for Antifa, red of the Bloods and blue of the Crips, those kinds of things. Just be a good witness. More than likely, they're going to be wearing a mask, so that doesn't help you any. You can note things like if there's hair sticking out of the hood, what color the hair was, were they female versus male. Good rule of thumb, a good tip for that one is, if they're wearing a hoodie and they're wearing a hood over top of their head and you can't tell whether it's a male or female, okay? From a physical physiology perspective, okay? From a physiology perspective, and we're not talking about what gender you were assigned at birth. We're not getting into that political quagmire of what gender you identify as today, that kind of thing. From a physical genetic makeup, the way that the bodies are physically made, as 99% of the time when you see a female walking versus a male walking, and both of them are wearing nondescript or unisex clothing to where it's hard to tell what gender they were assigned at birth, however you want to word it. The best way to tell is to watch the way the hips and the shoulders move. So in a female, because of the birth canal and the shape of the hips, a female will swivel as she walks at the hips, and her shoulders will remain basically stationary and straight. Her shoulders will not move or weave as she walks. Check out some catwalk videos and you'll see what I'm talking about. The hips move and sway, but the shoulders do not. Men are the exact opposite. Their hips will remain stationary and locked and centered, and their shoulders will sway as they walk. Okay, so good way to determine whether it was male or female and be able to articulate to law enforcement why you felt that was the case is to be a good observer and take good notes and be a good witness. Okay, we've gone off the rails here, but I think this is probably good information. Remember the guy who got into the argument with a lady parked in the handicap spot at the gas station? The guy ended up killing a man. I don't remember that, but that is one of those situations where you do not want to get yourself jacked up in, and you want to just be a good witness for the police instead of being a good witness on the stand when you're defending yourself to a jury of your peers a couple of years later after being in prison awaiting your trial. So it's tough, guys. It really is tough. And with the way that society's going right now and the things that are going on out there, you've got to arm yourself with the knowledge, not just, hey, I got a gun and I carry it because I'm the man, right? You got to arm yourself with some legal knowledge and some information so that you're a good protector of yourself and those under your family or under the mantle of your protection. Glad to hear that, sir. Glad that you enjoyed that. Georgia, yeah, I guarantee if GA stands for Georgia, I guarantee you're up in North Carolina a lot. My father was a truck driver for 99.9% of his life. He just recently retired at the age of 65, drove a truck from the age of 18 to 65 with only a couple of in between breaks to do other careers. So a lot of good, crazy stories there from the road, from Gravedigger. He was heavy truck driver, and he spent a lot of time in North Carolina, Tennessee, pretty much all over the United States. So glad that's good information. And you're right. If you go back and watch my Reciprocity 101 video from last week, you'll see that, Georgia, we reciprocate concealed carry with Georgia, but our laws may be slightly different than Georgia's. And so I went through a good walkthrough last week with that 101 video of reciprocity of how you can know the North Carolina reciprocity laws, legal laws in your state and any state you're going to be traveling to, and how to conduct interstate travel through the states like Maryland and other states that are non-permissive environments, as well as how to be obedient of the laws in the states that you're going to. So go back and check that one out. GA Trucker 69. And if you're not already a fan of the channel and liked and subscribed, do it, man. Join me. I'm hoping to keep pumping out some content. When you're up here in North Carolina, give us a shout out. Maybe if you're over in the area, we can catch you around somewhere. Which leads me to finally closing the doors. So thank you again for everybody joining me. I've gone an hour and 15 minutes. I apologize for going long, but hopefully it was valuable information. Until I see you out on the range or until I see you at a restaurant without a mask on, you keep living your dream.